Hello, welcome to the second in a series of pensions law web chats looking at technical bites on aspects of the Pension Schemes Act 2021, the new crimes, fines and penalties. This is the second in a series. The first was an overview and a look at regulator options and discretions. The second one looks a bit more depth at the elements of the two new main crimes under the 2021 Act. I'm David Pollard, I'm a barrister and a pensions lawyer. I'm at Wilberforce Chambers, and this is on the 6th of April 2021. These new crimes, fines and penalties are new powers for the pensions regulator under the 2021 Act. Later issues I'm going to look at include reasonable excuse, non-connected persons, the role of advice, that sort of thing. These webcasts are just meant to be discussions. They're intended for professional advisors. So if you're not a solicitor, you should go and get a legal advice from a solicitor. If you look at this, and if you are a solicitor, you should consider formally instructing a barrister. So general caveats and cautions, this is new legislation. It's not yet in force. We haven't got a track record from the regulator about when it's going to act. We haven't got case law from the courts about what these sections mean or what level of penalties are going to be due. And the risk of action by the regulator is going to depend on its policy. There is a draft prosecution policy that the regulator has very helpfully issued. That's not yet been finalised. That's mainly on when it's going to act rather than the actual ambit of the new provisions. These new fines and crimes both have a defence of reasonable excuse. I'm not going to talk about that today. Perhaps the next one will look a bit more into the reasonable excuse. The two main offences, avoidance of employer debt, broadly, or conduct risking accrued scheme benefits. There's also a new criminal offence in failure to comply with a contribution notice, but I'm going to ignore that for today. So we're looking at these avoidance of employer debt, which is an offence, and a new financial penalty provision that's up to £1 million, and in effect a new contribution notice ground, and similarly conduct risking accrued scheme benefits. As I said before, these are widely framed, not just employers or trustees, potentially catches lots of acts or omissions in relation to an employer or in relation to a pension scheme, or that affect an employer in a pension scheme. So if we look at avoidance of employer debt, that's section 58A, that's an act or a failure or a course of conduct that prevents recovery of a section 75 debt, that's the termination debt on a buyout basis for a defined benefit pension scheme, due from the employer, prevents such a section 75 debt becoming due or compromises such a debt or reduces the amount of such a debt. So it's quite widely framed, relates to an employer. The person intended that act, the act that caused the thing, or the failure to have that effect, and there's no reasonable excuse. Section doesn't apply if you were doing things as an insolvency practitioner. When it talks about section 75 debts, it includes a contingent debt, and it talks about preventing the occurrence of an event that would trigger a debt under section 75. That's issued by an insolvency practitioner. Rescue notices or failure notices, that then triggers section 75 debt becoming non-contingent. The other crime, conduct risking accrued scheme benefits, section 58B, an act or a failure or course of conduct that detrimentally affects in a material way the likelihood of scheme benefits being received. And the person knew or ought to have known that the intended act or failure to act or course of conduct would have that effect. So you talk about intention to do the act and then knowing that it would have that effect, or ought to have known it would have that effect. And again, no reasonable excuse. And again, insolvency practitioners are exempt. Accrued rights for the purpose of this is looking at leaving service accrued rights. It's the same definition as in section 67 of the Pensions Act 1995. And when you look at accrued rights, you ignore PPF and FAS benefits because they're going to be received anyway. And again, it's an IP exclusion. So there are three elements to both these crimes. There's causation. Did the relevant person, the defendant, do the act or fail to act that had the relevant effect? That's actus reus in legal Latin speak. For a financial penalty, you have to be a party to the relevant act, but I'm not going to deal as much with financial penalties today, probably do that in a future webcast, and you had intent and or knowledge and or purpose for the financial penalties. So there's an intention issue in there and no reasonable excuse. So if we look at causation, the first one, we look at these in 3 chunks. Causation, the act had the relevant effect. Must be a cause. Did you do an act that prevents a Section 75 debt? Well, Section 58A. There's no case law yet on this. What does that mean? But looking at other statutes, it probably doesn't need to be the sole cause, but it must be a substantial cause. There's a criminal case involving Cheshire. All of these are on the slides, the references, by the way, which you can get by clicking the link above me on the webcast. So cases like Cheshire and Hughes. Cheshire is hugely interesting for pension lawyers. A man shot in the leg and taken to hospital. He dies later because the hospital arguably were negligent in looking after him. Had he murdered the man, or was it the hospital? So you get this issue about causation. Similarly on Hughes, someone driving on a road gets crashed into by another driver. It's all the other driver's fault, but the driver of the first driver didn't have relevant insurance, and there's an offence of causing death while driving without relevant insurance. So did he cause the death? And the Court of Appeal thought, yes, he did, which seems a bit tough. And the Supreme Court agreed that that was a bit tough. So you get these causation issues are still going to be there. So did you do the act or course of failure act that prevented the recovery of the Section 75 debt or whatever it was? So what happens if you do an act that affects an employer, I don't know, take security or pay a dividend? Does that prevent recovery of the Section 75 debt? Well, if you do it, it's ongoing. There is no Section 75 debt due at that time. It's only going to become due in years ago. It may never become due. It might be when the scheme winds up, which might be years into the future. Have you done something that affected the Section 75 debt that was due? It's not clear. The contribution notice provision that mirrors this talks about a notional Section 75 debt as if an insolvency had happened. So that's talking deliberately about a notional debt. This, the same act, doesn't talk about a notional debt, just talks about a Section 75 debt that becomes due. So there are going to be issues on the prosecutor proving this degree of causation under Section 58A. Section 58B, an act or a failure of course of conduct which affects in a material way the likelihood. What's material and what's likelihood? Not defined in the act. Does it have to be over 50%? Does it have to be huge? Again, it's a probability test. Both of these sections talk about failure to act. So is failing to do something, failing to pay money into the scheme may mean that, or to the employer may mean there's less likelihood of the Section 75 debt being paid. Does that mean that everybody could be liable because they failed to pay? Does failure mean you only fail if you've actually got some sort of duty? Is that legal duty or moral duty? There's case law on this, which are on the slides, arguably talking about you need a legal duty, but in the Bonus case on the contribution notice, that held you didn't need a legal duty. You've got to have intent or knowledge. Corporate intent is quite tricky. Intent's usually subjective. It's not the same as desire or motive. Case law in the civil context talking about, well, was a military commander who ordered a military strike? Was he intending civilian casualties? He knew that would happen. What about foreseeability? Criminal case law talks about if you know something is virtually certain, then that might be an intent. Foresight of probability of a consequence, not enough probably, but can again be evidence of intent. There's the Section 8 of the Criminal Justice Act 1967, basically says you're not automatically bound to assume the natural and probable consequences of your actions, but that can be evidence of potential. Juries can draw inferences. And in later criminal cases, this is all become quite a bit of an issue. So how is intent established if you're talking about a claim against a company? Companies can obviously not be sent to prison, but can be fined, and that's generally directing mind and will. And there's a recent case, Serious Fraud Office and Barclays, which says that's true. That does tend to mean that large companies are less likely to have intent than small ones, and the Law Commission is going to be looking at this. So knowledge under Section 58B, knew or ought to have known, that looks a bit more objective. I put a chart in with the new crimes and kept the comparison table from last time. So that's come to the end of this particular session. If you've got any queries or issues, please don't hesitate to contact me. And I think we'll probably move on to the next one, looking a bit more at the reasonable excuse defence.